the vague mystery that a lot of people have been plagued with. A couple of things. The Constitution and its ability to self-execute itself. And notary protest. Whatever state you're at, or on a federal level, this thing called a Constitution, regardless of what part of it, or whether it's a Bill of Rights, what you always have to look at, and when you study certain cases, even though I really don't like using cases because it's their private instrument that they can alter and do addendums and amendments to based on their judge-made laws, which they call the appellate decisions. Appellate courts, when they make the last decisions, they can alter previous ones and make it what they want. So, nonetheless, which also leads to the fact that it's important for you to create your contract, which leads to notary protest and then misconception, which we'll deal with later, and why that's much better than you using case laws. But nonetheless, regarding the Constitution being self-executable or self-executing, the Constitution is an extremely spiritual document, spiritual tool. So much so that when you look at case laws, which is good to study, they would constantly reiterate something to you. They would tell you and use this phrase, the spirit of the law, the intent of the law. They're telling you that there's something about this thing that's beyond what you observe with your five senses. And you must function from that angle. It is necessary. You cannot avoid it. If you try to avoid it, that is when you just go gung-ho and you put something out there expecting it to work, and when it doesn't, you sort of get upset or disappointed. Then you finally lose hope and say, oh, these things don't work, or you guys over there don't know what you're talking about because I've tried it. Or maybe, I don't hate to break it to you, but maybe you were just clueless about what you were doing. I don't know everything, and I'm still learning and growing. But maybe you're just clueless. But here's a little helping hand. The intent and the spirit of the law is required in order for constitutions to be self-executing. What does that mean? It means whatever you see that these words tell you is exactly what it's intended to be. This is one of the most simplest documents you will ever read, regardless of what state you're at, regardless of what jurisdiction you're dealing with. Your Constitution is one of the most simple things you will read, yet it is one of the most powerful things. Because one section can basically cover everything else, which will lead to notarial protest and its importance based on obligations of contract, because you can secure everything within a Bill of Rights or the whole Constitution just based on contract. So when people use the Constitutions, which states one or the other, which either states that this has been prohibited or this must be done. Congress shall not pass this, or no person shall do this. No person shall be deprived of liberty, life, or property without due process. That's a prohibitory law right there. It prohibits those foundational aspects. So say someone trespasses against this and in fact does this, or somebody engages in a criminal suit against you without a grand jury, which is required. Says no person shall be held to answer for a criminal offense unless an indictment of grand jury. That's the first clause right there. And then it gives you exceptions as to how this requirement could be exempt. And these people don't qualify under these things, yet they engaged in supposed criminal activities. And you go, yes, that's true. But at the end, you're saying because they did this and that to you, or because they trespassed this, they now have to compensate you this amount or give you this amount. That right there is where the issue of self-execution lies. I'll repeat that again. The moment you bring money into the equation when it comes to constitutional and secured right, by the way, there's nothing wrong with money. And in fact, if someone trespasses against you, you should put monetary value in those activities, because that's based on rights and obligation of contracts, which we'll talk about based on notary protest and the misunderstanding of that also. But the issue most people face that causes this powerful document called the Constitution to not be self-executing is when they bring monetary value to it, monetary damages to it. And then you will get them telling you something like, when it comes to monetary damages, well, they don't directly tell you, but then they loosely just throw it out there and say, well, the Constitution is not self-executing. You don't have the right to make a claim upon which relief can be granted. Because the relief that you're seeking is that somebody give you a specific amount because this has been trespassed against. But nothing on the face of this Constitution says somebody has to give you an amount if it is trespassed against. And that right there is the key to why 12b-6 is thrown at 8 out of 10 people, besides the fact that people don't use the rule of evidence. Most people fail to state a claim upon which relief can be granted because they've steered outside of the lane of the requirements of this Constitution itself, without evidence of a contract or an obligation for the other party to compensate you that amount. So no person shall be deprived of life, liberty, or property without due process. They do this a lot. But now you come in and say, give me this amount because this man or woman has infringed my substantive right to life, liberty, and property without due process. They're going to go, okay, we see what you're saying, but you don't have the right to make that claim. The claim that they're telling you don't have the right to make is not the constitutional claim, but it's the monetary damages that you're seeking by way of the Constitution. They are not obligated to explain this to you. They will give you a general blanket response that will keep you lost in the sauce. The Constitution is self-executing. This is the most important part. This Constitution is self-executing from my experience under these conditions. When it comes to prohibition of certain things, aka injunction, and estoppel telling you not to do something. And secondly, when you've created your contract, right and obligation of contract, which you will bring it to show that this man is obligated to this because he's well aware of it and we have an agreement and a meeting of the mind. So therefore, he or she owes me this amount, or this entity owes me this amount. It's all about contracts. The people who created this document called the Constitution were some cold motherfuckers. Extremely intelligent people. And they understood how commerce works. This is, in fact, I don't care what anyone says, this is a commercial tool. Is it limited to commerce? No, it's not. But you can kick a lot of ass in commerce if you know how to use this. This is probably the most powerful commercial tool ever. Because other operation of law, legal aspect, legislation that are created will be based on the foundational principles set herein. And when people are thrown the 12b-6 brick, something always accompanies that brick. An explanation of why they slapped you with that brick. The explanation usually goes something like this. Absent of legislation that enforces the Constitution, the word and the spirit of that Constitution itself makes itself executed. In other words, if it says no person shall be deprived of life, liberty, or property without due process, and you were in fact deprived of these things, and then you bring that into the public venue, then what you have to do is an injunction against them to not do that again. When you begin to bring monies into it, you should bring that in through your private contract. Because nowhere here does it say this man or woman is going to give you this amount if they break this law, or if they do this, or if they don't do this. And there goes the second part where they say absent of legislation. Legislations will tell you based on what state you're at, whereby if the security of property has been trespassed against, theft, vandalism, whatever it is, this man or woman will pay this penal sum of so and so. But most people has been so traumatized with being on the other end as defended by all these state legislations being used against them that they don't even think twice to use it themselves. They don't even have to use the verbiage itself. Just use the principle and concept. And the solution is right here. No ex post facto law, meaning anything else outside of the law that's created herein or in your contract. A law impairing the obligation of contract. Obligation. You have to make someone obligated. First way you do it is to create prohibitory and injunctive relief by putting them in notice. That is all notary protest is all about. Simply putting notices out there. If then algorithm. And then it is after that that you're able to make claims for monetary damages. But you don't necessarily have to use that verbiage injunction. You can use other things like notary protest based on whatever the intent and the spirit you want to move here. That notary protest is a form of legislation in a way which will be shown based on the state law and the UCC. They can create legislations as they see fit for certain circumstance, because even then all those legislations have their own monetary value to it based on the statutes of limitations. So they're just running their business affairs. Congressmen are just trust members, just having their own meetings, running their own trust. You ought to be doing the same thing. They are using this powerful tool to their benefit. You must do the same thing. Create those laws and contracts. But nonetheless, most people will face an issue like this. This is a case where someone was suing a school district regarding sexual assault. And this case law basically lets them know that, okay, we're not saying you don't have the right to not to discriminate based on your gender and to not experience, ridiculous things like sexual assault. But what we're saying is your claim is based on monetary damages, right? And there's no law that's saying that we can move on these monetary damages that you're claiming. Remember, we're all parties to a trust. Judiciary, all that are just divisions, or how do you say, roots or stems of a tree. So if you go to state court, state is a trust. The home rule unit, the political subdivision of its own. The judicial branches of it, whether it be an actual court of record based on what the state constitution stipulates, or maybe it's just some other inferior courts just doing their own regular business, just making that money. Whatever it is, they're all still part of trust, and they have limited confined space they can function. And they look at the legislation, which is the operation of law that they're limited to. They look at it, okay, can we give this amount out? No, sorry, we can't. We see this little girl got raped, but what you're telling us to do, we can't do it. And here it is. It says the school district moved to dismiss count 6 of plaintiff's complaint, arguing a private right of action for damages. See that? Was not implied under Article 1, Section 18. Alternatively, the school district asserted that even if Article 1, Section 18 allowed an action for damages, plaintiffs were barred from recovery by Section whatever of the Local Government and Government Employee Tort Immunity Act. See that? This second part, the if second part, they're referring to, they're indirectly telling you that if you really want us to be liable, you can't sue our entities. You have to sue us in a personal capacity. And another place where most people fail when they bring damages is, say you're suing the CEO of an entity, supposedly in a private capacity. So James Wells is the CEO of Corporation A. You're suing James Wells as a CEO in that capacity, right, of that entity. And then you also suing James Wells in his personal capacity. But when you did your summons, what you did was you only send that summons, service or process, to the agent of that entity. They will bring this up because you have not done a proper joinder of parties to make them personally liable. For you to make them personally liable, you have to join them personally by serving them wherever they domicile, wherever they lay their head, wherever their private place of abode is. You cannot serve the registered agent and expect the private man to be liable for that. You can't do that. And that is why they brought this up. This one simple sentence lets you know, look, it doesn't say that they can have damages according to this specific part of the Constitution they're bringing in. And even if it does, they didn't do a proper joinder of party. So because of that, we're bringing up our private law that says our entity cannot be held personally liable for actions of people who are private. So we're immune. That entity did not engage in a torture. An entity cannot torture another man or woman. That's simple. Look over this case when you get a chance and just read in between the lines. The Circuit Court denied defendant's motion to dismiss count 6, finding that the right of action for damages was implied under Article 1, Section 18. To which the Tort Immunity Act were inapplicable in reaching this conclusion. The court reasoned that a school district's policy of acquiescence to sexual harassment of female students by male students, resulting in an educational environment hostile to females, presented a viable basis in which a private action for damage could be maintained under Article 1, Section 18. Policy. The moment they begin to talk about policy, know that they're talking about an entity. And now, this private right of action that they're talking about here is not the private man. They're talking about school district as a private entity. So if you want to hold man or woman liable, join them personally. Or else the private right that you have enforce the Constitution will be limited to policies and corporate entities. But if that's what you seek, then that's fine. Some might read this and say, yeah, private right of action did exist. Yeah, but still in a corporate capacity, which there's nothing wrong with. If that's what you want to do, go right ahead and do that. Because there are private corporations and public entities. And here is the important part when it comes to damages, self-execution of constitutions. It says the pivotal question, meaning the important question presented for our consideration, is whether a private action, meaning they're not saying that the school district, they're not disputing whether it's a private entity or not. In fact, they're telling you that the school district is a private entity. They're letting you know. But now they're saying, well, okay, but do you really have the right to damages if you're bringing in the Constitution? The pivotal question presented for consideration is whether private action for damages can be sustained under Article 1, Section 18 of the Illinois Constitution for sex discrimination. Then it goes and read out the verbiage. Equal protection of the law shall not be denied, prohibitory. Then an injunction is the proper thing. And then do a notary protest. Create that agreement of that monetary damage. Create your own operation of law. If any legislation is created to hinder you creating an operation of law based on the substance of what you are, and you, the people, gave them the power for that to even exist, then they are infringing the obligation of contract. And they are, in fact, creating ex post facto law. The equal protection of the law shall not be denied or abridged on account of sex by the state or its unit of local government, school district. It says nothing here that if it now had this specific section continued on and said, if this is violated, or the violators of this section of the Constitution will be liable to this blah 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 amount, then it becomes self-executable. Then it becomes self-executed. Damages. The key here is the damage that people claim, the monetary amount. That is what makes the bread soggy. That is what makes the soup too salty. Again, the pivotal question presented for our consideration is whether a private action for damages can be sustained under Article 1, Section 18 of the Illinois Constitution, which is where they're bringing a claim. And they're saying, pay me this amount because of this part of the Constitution. But they're saying you can't sustain that claim because the part of the Constitution simply provides that you shall be equally protected. But now, we're not saying you were equally protected, but you didn't state a claim on which relief that you're seeking to be granted. The relief you're seeking is, on its face, does not state that you're qualified for damages. So one or two things occur in the operation of law, which is a legislation of the state that says, if somebody has been damaged or has not been protected based on certain activities, then they're liable for certain damages. Then they go on. The drafters intended Article 1, Section 18 to expand upon the general guarantee of equal protection conferred in Article 1, Section 2 by designating gender a suspect classification. However, there is no indication that in expanding the general guarantee of equal protection, the drafters intended Article 1, Section 18 to provide for private right of action for damages. Right there, it tells you the intent was, in fact, gender specific and to protect certain substantive right whereby people are discriminated by their gender. However, there is no indication, besides all this legalese crap, It simply says there is no indication that provides for private right of action for damages. This is where they get you. Money is really important when it comes to business. When you begin to sink into someone's pockets, they will find every loophole, tell you, no. There's nothing wrong with you seeking monetary damage. But the Constitution is so great that it leaves such an open space for you to create the reality that you wish. And it gives you the foundation that points you into the general direction. Because all of the Bill of Rights, or most of the Constitution, will always tell you all men are by nature free and independent. They're telling you you are not bound by these things that are written down. In fact, the power comes from you, deriving their just power from the consent of the governed. To secure these rights and the protection of property, governments are instituted amongst them. Among these are life, liberties, and pursuit of happiness. Sometimes reading it backwards actually makes more sense than reading it in the general angle. Sometimes you gotta go the old school version of reading it almost from left or right to left for it to actually make sense. Because the brain digests information differently that way. It's telling you, you have the power, and they make it the first section. And that everything that's written here, you're not limited to it. So they even reiterate it. This first section right here is really all that's needed, but everything else is just a reiteration of this. They even reiterated by telling you, look, no one can impair your right to engage in contract with anyone. And no other law can be created to abridge this that serves as a roadmap to that which you enforce. So if you are going to bring in monetary damages, just make sure you've created a contract and an agreement. Because the intent of the law does not provide for damages. You can use state laws that says, hey, simulation of legal process, you owe me this amount. Hey, battery, you owe me this amount. Hey, civil right, you owe this amount. Human rights, you owe this amount. But even then, when you read the intent within those legislation and public acts of the state regarding all these things people experience, they limit your remedies. And sometimes they don't even provide for monetary damages. So they will tell you, yes, you have a private right to sue the corporation, or if you've done great investigation, you can bring them in personally by serving them in their private place of abode. And even then, does the Constitution provide for monetary damage? The intent of the drafters, how do we know? Well, we look at what's on its face, on its four corners. There's a lot of injunctive relief here. You can bring that in, or bring in your own contract. It's really that simple. Then they give other comparisons. In Baker versus Miller, in Baker, the plaintiff attempted to bring an action for damage directly under Article 1, Section 17 of the Illinois Constitution based upon the same matter, sex discrimination in employment. Circuit Court dismissed plaintiff's claim, and the appellate court affirmed, finding that an action for damage. Listen very carefully. They're not saying you don't have a constitutionally secured right. They're not saying you have not been damaged. Damages just means money. They're not saying you have not been injured. They're not saying that there's not been a trespass on your constitutionally secured right. But what they are saying is that finding that an action for damages cannot be brought directly under these sections. On appeal to the Illinois Supreme Court, the plaintiff argued that she should be permitted to bring an action for damages directly under Article 1, Section 17, because the Illinois Human Rights Act did not provide her with a means for private recovery against her employer. By the way, the Illinois Human Rights Act basically just limits things to businesses and doesn't really give you any tabular calculation of damages. Look at the ones that correspond to your state, or look at the United Nations versions. Just read it. The court agreed, meaning she just did a self-confession. She just said, well, I have no remedy to bring damages, so I'm bringing mine. And they said, yeah, you're right, you don't. And that's exactly what we're saying. But what they're not going to say is, well, you should have created your private contract that shows that this man or woman really owes you this amount based on this, and you just exhausted your remedy through an injunction first. The whole thing about UCCs and non-UCCs, it's just another way of categorizing what a debtor and the creditor is. It's really just that simple. But nonetheless, you still have to use the Constitution for you to be able to enforce any monetary damage. But that shouldn't be the limitation. Enforce your contract. But moving on, it says the court agreed with the defendant that although an action for damage, money, for sex discrimination could generally be brought against an employer under the Illinois Human Rights Act, the defendant was exempted from liability under the Act because employing less than 15 people. So they will bring up another corporate crap. Why? Because you didn't join them personally. An entity that is not speak for itself cannot damage you or your rights. That's what they're saying. If this been brought as a trust in capacity of a trustee of a trust, that would be a different issue. So you see all the little nuances that we've been thought wrong about, and an attorney is definitely not going to tell you these things because it's not their job to. Again, there's nothing wrong with attorneys. If they can accept your terms and conditions, good. Do business with them. But if they don't, hey, best of luck. And then it goes on to say plaintiff was foreclosed, meaning barred from bringing a damage action directly under Article 1, Section 17, even if a private remedy was not available to plaintiff under the Human Rights Act. This is the legislation that supposedly was supposed to create that right for damages. Even if it doesn't give you that right for damages, you're barred. Why? Because you haven't created yours. And they never tell you, hey, you cannot create your contract, because the law says no one can stop you from that. So one, when you sue somebody in their personal capacity, there has and there must be a joinder. There has to be. There must be a joinder of personal capacities. Two, Constitution is in fact self-executing, but under the spirit of the law itself. Whatever it says in its face is what's self-executing. If you want to bring money into the equation, fine. There's nothing wrong with that. Just make sure that you create an obligation on the other party to be liable for that money. A contract. Then your claims of the violation of any of these sections will then be a scope, the private right of action of enforcement of contract. If you don't create this obligation of contract, what you're doing is you shooting an arms without really knowing where and how it's going to hit. And you're just hoping it somehow magically hits or the wind blows to your benefit. It's not going to work like that. And if you're not going to create your private contract, find a state legislation that favors your cause of action. If you're looking for damages, find a state legislation that stipulates certain amounts that you're satisfied with, and bring that in as the operation of law. Legal things are operation of law. And how you enforce it is the operation of law. Put it to use.